We're live.
All right, everybody. Welcome to today's Revenue Subcommittee meeting. It is March 18th. We are going to review 5 bills today. To our guests who are with us, just a reminder that you should keep yourself muted at all times. If you want to add something or something, then you can raise your hand. We may or may not go to you depending on time. Or if a member of the committee has a question for you, they can ask you a question that way. So members of the committee, I'm just going to go in numerical order here. We will start with House Bill 495, which is a bill that we discussed previously. This is the bill that has to do with decoupling from the Federal CARES Act. There's a set of amendments which you all should have, and what those amendments do is they strike the provisions of the bill that retroactively decouple from the 3 CARES Act provisions that were in the bill. But going forward, they resolve this issue that we've had with Maryland's automatic decoupling law to say that Maryland will automatically decouple prospectively from retroactive federal tax changes, which is a freaking mouthful. But that's kind of what the amendments would do. I've discussed them with the sponsor. I think we've also gotten some feedback from the comptroller's office that fewer companies than we thought had taken care of and Delegate Polakovich Carr, tell me if this is a correct characterization, fewer companies than we thought had taken advantage of the CARES Act provisions in question. Is that the way to describe it?
Yeah, there have not been very many amended returns filed to date. I mean, they still could be coming, but to date, not so many.
So a bit of a compromise position on the bill. Delegate Buckle, go ahead.
So just to summarize it, so I know what we're voting on and can explain it, we're going to remove the retroactivity provisions. So the CARES Act itself really isn't going to be the touchstone for how we implement this policy. But we're going to take the policy going forward that says if the federal government passes bills in the future that would allow for these restated earnings or refiling deductions to exist, that the comptroller can step in immediately the way they do now under the same law that says this may have this threshold impact for Maryland revenues, and we do not automatically decouple, but we hold the decoupling decision for legislative input. Is that a reasonable explanation of where we're at?
That's a correct characterization, yes.
Okay, I'm fine with that.
I'm hopeful that the feds don't do this again. I mean, my understanding is they had already made a policy decision to sort of stop doing carryback provisions and had focused instead on carry forward, and then they kind of reversed themselves in the CARES Act. So, hopefully this doesn't come up again, but in case it does, I think it's consistent with our existing decoupling policy.
That's what happens when you're passing 1,800 pieces of legislation, 18,000 page pieces of legislation in a day. It's like, yeah, that's in there. I don't know why that's in there, but it is. Yeah, I think that's a very good and valid compromise that everyone should be able to explain and think is rational. Thank you.
Delegate Feldmark.
Thank you, Mr. Chair. I just want to clarify, I may have misunderstood slightly what Delegate Buckle said, but so just to make sure I understand, this says that going forward, should the federal government implement retroactive changes that would have a negative impact on our revenue, they will be automatically decoupled. And then if the legislature chooses to pass legislation to adopt a parallel provision, we can, but
Yes.
in the absence of any legislative action, they would not impact state revenues retroactively.
That's correct. So it would put us in the same position in regard to, similar sort of, retroactive tax provisions as we are in same tax year provisions currently.
Okay, great. Thank you.
Mr. Chair, can I make a clarification on that?
Sure.
So actually, it's a little more convoluted than that. So under the current state law, it's just it's a decoupling for just that current tax year and calendar year that Congress made the changes. So it's possible that there could be some hypothetical situation of where Congress makes some retroactive tax change that would at least be decoupled for 1 year, but maybe still has like future years included in it. I wouldn't characterize it as we'd be decoupled automatically from every retroactive change. It probably is going to catch 99.9% of them, but.
All right. Any further debate? Is there a motion on the amendments?
So move.
Second.
Any discussion on the amendment? All those in favor, please raise your hands.
Aye.
Any opposed? On the bill as amended, is there a motion?
Move favorable.
Second.
All those in favor, please raise your hands. Any opposed? All right, that bill moves forward. HB 804 is a bill that had to do with the creation of a whistleblower reward program to help catch people that may not be entirely following the rules in terms of filing their taxes. Following our conversation last week, I guess it was, I've lost track of time at this point. Delegate Polakovich and Carr and I had a series of discussions with the Office of the Attorney General about some of the concerns that were raised with conflict of interest provisions. There's a set of amendments that have been drafted that would retain within the comptroller's office both the questions of, both sort of sides of the equation, but eliminate some language that was leading to some of those concerns about potential conflict of interest. So I'm going to turn to Delegate Polakovich Carr to explain them in a little bit more depth.
Right. So the amendments before the subcommittee are based on the input of the Attorney General's office. A lot of them are clarifying in nature, but probably I'll just highlight a few of the more substantive pieces. One of the amendments, this is under amendment to kind of end of that first paragraph, where it's saying striking penalties and interest. So this is making it so that the threshold for a case that could be brought forward by a whistleblower is $250,000 in taxes. No longer would allow penalties or interest to count towards that dollar threshold. At the bottom of the first page of amendments, we are adding language to clarify if there's more than one whistleblower that comes in on the same tax case, how the award money should get allocated, and clarifying that that is still capped at up to 30% of the money that gets recouped by the state, so that the state is losing out on any additional funds there. On page 2 of the amendments, kind of middle of the page where it's talking about page 5 of the bill, we're adding language to clarify another, or to remove another situation where an eligible, that didn't make any sense. Okay, page 5 of the bill. We're basically clarifying that there's another situation in which someone would not be eligible for the whistleblower reward, which would be if they could have been convicted of a statute of limitations had already run out under the criminal code, but the statute of limitations hadn't run out on the tax fraud code, that they're not eligible basically to be part of this program. And the bottom of page 2 of the amendments, add some additional clarifying language in regards to when a whistleblower could challenge a decision by the comptroller's office, and it's specifying that the whistleblower may not challenge whether or not the decision to conduct an investigation, the amount of unpaid taxes, penalties, and interest due to the state, the result of a covered enforcement action or related action, and the settlement between the state and the person who owed the taxes. So the whistleblower can't bring any challenges in those areas. We're also now on page 3 of the amendment, adding language clarifying that the whistleblower is not entitled to attorney's fees. And then the last 2, I guess we'll call them paragraphs on page 3 of the amendment, we previously discussed in subcommittee, it strikes language that the comptroller's office had previously flagged as being problematic and relating to disclosure of information. So again, we're striking part of the bill so that less information is potentially being shared in regards to a tax case.
And in terms of the conflict of interest concerns that were raised previously, the removal of penalties and interest from the in the first part of the amendment that Delegates Polakovich Carr described significantly reduces that, right? Because penalties in particular are discretionary to some extent. So it removes some of that discretion from the conversation. Now, the comptroller's office would still need to create a wall of separation. That would have had to happen regardless, even if we put part of this in OAG, because they'd have to create a wall of separation between their AAGs that work with the comptroller's office and whoever was making the award decisions. So this will still bear some work by the comptroller's office to figure out exactly the way to do this. But I think a lot of the concerns have been addressed, at least partially. Questions on the amendment? Okay. Is there a motion on the amendments?
I'd like to move them favorable.
Second.
They've been moved and seconded. Any discussion on the amendments? All in favor, please signify by raising your hand. All opposed? Okay. On the bill as amended discussion. Is there a motion?
Move favorable.
Second.
Moved and seconded. All those in favor, please raise your hands. Any opposed? All right. Bill moves forward. Thank you. HB 864 is the bill that has to do with creating a slight bump in the income tax subtraction modification for military retirement income. The amendments that previously had been under discussion reduce that bump from a bump up to a doubling up to $30,000 down to $20,000 to manage the fiscal note a little bit better. My understanding is that some of the questions we had last time have been clarified for people. So I want to, I don't believe we adopted the amendment yet, but I want to see if there are any questions on the bill right now. All right, I'll move the amendment.
Second.
Any discussion? All those in favor, please raise your hands. Any opposed? All right, on the bill as amended, is there a motion?
Move favorable.
Second.
Moved and seconded. Any discussion? All those in favor, please raise your hands. Any opposed? All right, that bill moves forward. HB 892, I told Delegate Buckle we would only move this bill if he resigned from the legislature, so.
I'm out. That's the big bill. That's the $20 million bill. The $20 million bill, I mean, I'm done. Yeah.
Yeah. So just for people's edification, the fiscal note on this bill estimated a fiscal impact of $2.5 million. That's an estimate of future appropriations. The bill itself does not create a mandated appropriation. It creates a grant program. And so, you know, future governor could fund it at 2.5 million. They could also fund it at 0, right? And of course, the legislature will be able to weigh in on that appropriation as well. So, you know, from my perspective, just personally, and I appreciate, you know, the work of the fiscal note writers trying to estimate what the potential cost will be. I see this as a 0 fiscal note and leaving the actual fiscal impact up to the appropriations committees and the governor personally. But I do believe we have some amendments. Oh, sorry, Delegate Feldmark, go ahead.
So thank you for raising that, because that was one of the questions I had. And so then related to that, they included the 2.5 million estimate for fiscal year 22, but there's nothing in the FY22 budget anticipating this, correct?
No, that's right. It's
Okay.
simply creating the program for TEDCO to administer and the purposes to which they can administer. TEDCO suggested that 2.5 they thought would be sufficiently robust for the
Right.
meeting, but we
Okay.
intentionally elected to not mandate that and require it that it be put in this year's budget or even next year's. We'll advocate for that with the governor's office in the years to come and certainly with the legislature, but it's
Okay.
not a required year-to-year appropriation.
Okay, that made sense. I just was surprised to see that estimate included in FY22 also, but thanks.
I know Delegate Polakovich-Carr has a verbal amendment she wants to offer, but first, George, did we have some technical amendments on this as well?
That's correct. I did prepare some technical amendments to correct a typographical error and to clarify language relating to the auditing of the fund and its uses.
I move the technical amendments.
Second.
All those in favor of the technical amendments, please raise your hand. Any opposed? Delegate Polakovich-Carr.
Thank you, Mr. Chair, and had a chance to have a text conversation with the sponsor of the bill. In general, I like the bill. When I was thinking about who the proposed membership of the board was, though, I thought that perhaps that body would benefit from having additional area of expertise represented, and that would be to have somebody who has a background in venture capital or economic development. And so that was the amendment I was going to propose. I will say it occurred to me just a few minutes before we started our meeting that if we add one more person to the board, I think there's 5 members right now, that would add a 6th member, and it would be an even number of members. And oftentimes we try to avoid that because of ties. So I don't know if the sponsor of the bill would like to avoid that situation or do something else to try to avoid a tie.
I'm okay with it. I mean, I think in boards which are sort of policy setting boards and may have, a lot of really contested votes, obviously math is math and we want to do that. This board I would be very surprised that there's ever really any contested votes because it's simply within TEDCO and within this group to exist to facilitate the grant program. So I'm perfectly fine. I think your suggestion made sense for getting people that are the expertise added, and I'm fine with doing that.
And I should clarify that person would be appointed by the governor, just as the 2 members who are entrepreneurs or from the business community, as the bill currently
Same
states.
language.
You didn't want them appointed by the delegate from District 1B?
Maybe.
All right. So Delegate Polakovich-Carr moved that amendment. Is there a second?
Second.
All those in favor of the verbal amendment, please raise your hands. All opposed? Okay. So I'm going to ask the chair if we can move it as a verbal amendment in full committee voting session as well, because it hasn't been drafted yet. So assuming she's okay with that, it shouldn't slow down processing of the bill. But even if we'll have another voting session tomorrow, so even if we hold off for a day, we still got plenty of time. It'll definitely get across before crossover. Okay. On the bill as amended, is there a motion?
Move favorable.
Second.
Second.
All those in favor, please raise your hands. Any opposed? All right. And last bill of the day, HB 1209. I will just say from my own personal perspective, I hope after today, I never have to talk about peer-to-peer car sharing taxes ever. So the speaker convened kind of a series of meetings between myself, representing the Ways and Means Committee, Delegate Corman from the Appropriations Committee, and Delegate Wilson from Economic Matters Committee to try to look at a number of issues that have been raised as part of this sort of ongoing expansion of the P2P car sharing industry. And those conversations resulted in the amendment that was sent out earlier. I will say this bill, assuming the subcommittee wants to adopt these amendments and move the bill, would not touch the excise tax at all. I think that's a separate, larger issue that we may want to have conversations about. It also would not impact the issues at the airport. Those are issues that are going to be addressed potentially under separate legislation that I believe is in ECM and duly assigned to a probe. So I'm not sure exactly what the committee assignment structure there is. So, what the amendments propose is that this bill would only deal with the actual rental taxes, essentially. And what the amendment does is it adopts a model that our neighbors in Virginia have used in differentiating on the peer-to-peer car sharing sites between large fleets and small fleets, right? Arguably, if you have more than 10 vehicles on Turo or what's the other one, Get Around or whatever it is, then arguably you're a rental car company, right? And you should be paying the same, you should be charging the same taxes as any other rental car company. At that level, you're also eligible for the excise tax exemption. Under 10 vehicles or 10 or fewer vehicles, it would maintain the current tax rate. So what the amendments propose is that for fleets of more than 10 vehicles, the tax rate would be 11.5%, as it is for rental car companies. 10 or fewer vehicles, it would be 8%, as it currently is for P2P car sharing companies. So it's kind of an attempt at a compromise to split the baby. I've talked to representatives of kind of both sides in the both industries. And while nobody is jumping up and down and shouting for joy, they both kind of said, we're not going to fight that. That seems like a reasonable approach. Although, you know, I'm sure that the conversations will continue in the Senate should we choose to send the bill over. So that's where things are at. That's what the amendments in front of us do. Delegate Buckle.
So it doesn't deal with the excise tax at all, which is great. It's raising tax, not raising tax, I shouldn't say that. It's conforming the tax for what we're defining as large fleet to the 11.5% rate, and it's leaving the rate for independent operators or people who are doing this with their own cars or with 2 or 3 cars independently. It's leaving their rate at the same relatively low percentage.
That's correct. And look, you know, for members of the minority party, I think, you know, there will be people that will argue this is a tax increase. So I get the voting dynamics for members of the minority party on this. I
hate to say it that way. I don't really personally look at it that way, in the sense that we're basically just taking a business that should have been categorized or possibly should have been categorized as a rental car company and you know, changing the name. Analogize it to my industry. If I had a law firm and there was a law firm tax that said, you know, providing legal services, you have to have a law firm tax. But if you just do it by yourself as a sole practitioner, well, then there's no law firm tax. It's the same business. You know, we just separate everybody else up into different offices within the building and say, well, we're not together. We're not a firm. We're just independent lawyers, so we can avoid the tax, but it would be the exact same business.
I saw Delegate Feldmark and then Delegate Long.
Thank you, Mr. Chair. So I guess we're eliminating the sort of phase in, right? It's going to be an immediate jump for the folks who are impacted, but we're shrinking the universe of who's going to be impacted, because instead of a threshold of 5 vehicles, it's now 10.
That's correct.
Correct. And do we have any sense of how many people or entities participate in peer-to-peer car sharing with more than 10 or between 5 and 10 vehicles? Like, I'm just wondering what that actually means in terms of who's impacted.
So the impact is relatively small. I asked Turo and received numbers for them, and I don't want to share their numbers in detail because I don't want to, you know, reveal their sort of business model. But my understanding is that the increase on the of more than 10 vehicles will affect exactly 2 entities. At least right now. Now, this is a growing industry, and we'll see, you know, what happens down the road. Delegate Long?
Yeah, just want to clarify, you said anything over 10 cars, you would be raising taxes on, am I correct?
So any owner that owns more than 10 cars would have to charge the same rate that rental car companies currently have to charge.
Okay, so I'm not familiar how the model works with rentals, but is each individual considered their own business? Am I correct?
Within the, you mean on the rental car side or the?
Yes, on the peer-to-peer side.
So what's happened, there's a range of essentially business models that are coming into existence under peer-to-peer. You've got some people that just, you know, they own a car, but they never use it on the weekend. So they're renting it out on the weekends through these sites. And then you've got people who are trying to essentially create rental car businesses where they're renting out the vehicles. I mean, if you've got more than 10 vehicles you're renting out, that's business, in my opinion, right? So that's the differentiation. And, you know, like to differentiate between the two, at some point you're just picking a number, but 10's a reasonable number. And as I said, Virginia differentiated at 10 as well.
Thank you.
Delegate Buckle.
I mean, I just, as you were saying that, can we couch this within the range of, it's not a question of raising taxes or changing tax rates. It's changing the definition or providing a definition or law of what is a rental car company. It's really not about the tax rates. It's saying rental car companies have, the existing rental car companies have paid this rate, and we are now going to better define what a rental car company is.
I think that's a reasonable characterization within the tax general article. Now or I guess this is in the transportation article, but on the business regulation side, they are still regulated as different types of entities.
Okay, because I mean, that to me logically is the import of what you're saying is we're treating people who have 11 vehicles and are using them for their primary purposes to rent them out for rides as a rental car company, which that makes complete sense to me, as opposed to somebody who's saying, myself and my spouse, we have 2 cars and we're doing this on the weekends to make extra money running from the airport or downtown Baltimore, or whatever. That's not a rental car company. That's just people, you know, providing a service.
Right.
Okay, thanks.
Are there further questions? All right, I'll move the amendment.
Second.
All those in favor of the amendment, please raise your hand. Any opposed? On the bill as amended, I move favorable.
Second.
Any discussion? All those in favor, please raise your hands. Any opposed? All right. So I believe, and you know, this could always change, and every year I say this, and then something else pops up, but I believe that means we're done before crossover with revenue subcommittee bills. We will, you know, something could pop up. If it does, I will let you know as soon as possible. But then we will also be getting legislation from the Senate, and we'll start having hearings on those next week, and we'll be able to start moving on those. And as I mentioned before, I think our first order of business is going to be looking at the Commerce departmentals related to the research and development tax credit, the biotech investment credit, and cyber investment credit. So those we'll probably have a subcommittee meeting sometime next week on those. But other than that, you know, I think hopefully subcommittee won't need to get together again between now and crossover. So any questions from any members? All right. Thank you all very much. Have a good rest of your day.
You too.